I understand there's been a recent UK Court of Appeal judgment which is of real interest to our clients. Can you tell me something more about it, please?
Yes, although it's not a financial markets case, it is a case which is going to have an impact on the financial markets. It's a case all about waiver by conduct. And although, as I say, it wasn't a financial markets case, it has impact for the financial markets. In that case, the post office contracted with another party to provide it with goods and services. And those goods and services were meant to be supported by a parent company guarantee. And basically what happened was that the guarantee wasn't given when it should have been. And then some 9 months later, the Post Office Limited basically terminated the contract on the basis of not having received the guarantee.
The clause you allude to, what exactly does that say?
The clause is something that all financial markets lawyers will be familiar with. It's the one which says that even though there may be a delay or forbearance in enforcing your contractual rights, that shouldn't be regarded as a waiver of your rights.
That sounds pretty straightforward. What in fact did the court say?
It is straightforward, or at least we thought it was going to be straightforward, but the court at first instance very much said, it says what it says on the tin, so they gave it its full terms and effect. The Court of Appeal, however, came along and said no. In fact, it wasn't prepared to enforce the clause.
What was the reasoning for the Court of Appeal's judgment in that case then?
The reasoning wasn't entirely clear, but basically what they seem to be saying is that it was a form of exclusion. And they said that if you were going to exclude what is known as the Doctrine of Election, and I'll come back to that in a second, that if you were going to exclude the Doctrine of Election, you had to say so in terms. Now, the Doctrine of Election, as you probably remember from law school, is that whenever there is a breach of contract, you have two options. One is to sue for damages immediately on the limited breach, or if the breach is sufficiently serious, you can terminate the whole contract and then sue for the wider breach. But you basically have to choose between affirmation, which is the first one, or termination, which is the second one. And in these circumstances, the Court of Appeal also said, even as a matter of public policy, they questioned whether or not any party could exclude the Doctrine of Election.
That's all well and good, but what about the intention of the parties in that case then?
I think what the Court of Appeal said in this case, in effect, was they were concerned that there had been a cynical use of the protection that the clause is intended to provide, because basically the Post Office Limited knew of the breach and sat on it for 9 months and didn't say anything to the other party, didn't warn the other party, and then all of a sudden it pulled it out of its back pocket when I wasn't happy about something else and said the contract's terminated.
In the derivatives world then, where there are similar clauses in an ISDA Master, does that mean a similar clause is going to be ineffective?
Well, there's always a risk, and of course it's not just the ISDA Master. This clause appears in all sorts of financial markets contracts, whether they're loan agreements or other form of derivative contracts. And there is always going to be a risk if there is a delay without purpose. So what we're saying to clients is, where there is a breach, you have to make clear to the other party that there has been a breach and that you are holding off from suing or exercising any of your rights based on the clause.
Often in current climate particularly, where there is a default, counterparties, rather than calling an event of default, will look to find a form of amicable solution. If they go down this route, does it mean that a party is therefore losing some of its rights? Is it prejudicing its position?
Because of the case, there is always going to be that risk. But as you say, it's not unusual where there has been what is technically an event of default for it not actually to be used as an event of default, because it could have far wider ramifications for the counterparty than is actually intended. So it's not uncommon for the parties to negotiate some sort of amicable resolution. And provided it is made clear that that is the purpose of delay, then I think that you're going to be much safer, because in those circumstances you don't have, what you're not doing is using the clause in a cynical way, but in effect to the mutual benefit of both parties.
And finally, just to conclude, we've looked at the legal analysis. Can you just give some more details in terms of practical advice to our clients in the light of this judgment?
Yes. I mean, as with all sorts of litigation or pre-litigation, an audit trail or paper trail is absolutely essential. So where there has been a breach, it has to be identified as a breach. You don't actually have necessarily use those terms because financial institutions don't necessarily want to be quite so stark. But it has to be clear that one party has not performed its obligations to its full extent, and then for there to be some correspondence or communication between the two parties as to what the objective of not enforcing your rights immediately would be. So it has to be clear that there is a positive goal in sight if you're not immediately exercising your rights.
Thank you very much for your time, Paul.